Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Andariki Shubhodayam. In this video, I am going to touch upon a few experts, EXCRPTS, of the lecture given by Honorable CJI Bhushan Ramkishan Gawai in Calcutta, in Kerala, in memory of our 11th memorial lecture of late Justice V.R.KRISHNA IYER. The topic is role of Justice V.R.KRISHNA IYER in balancing the fundamental rights and DPSP, that is the Directive Principles of the State Policy. Honorable Chief Justice of India B.R. Gawai stated that the principle of Justice V.R.KRISHNA IYER, that bail is the rule and jail is an exception, is forgotten nowadays. But he has got the chance to reiterate the principle in a couple of cases. A meeting was held recently in Kerala High Court premises in memory of late Justice V.R.KRISHNA IYER. Padma Bhushan. I think Padma Vibhushan also, I will tell you in the last. 11th Memorial Law Lecture in Kerala High Court. So, Chief Justice opined that the principle on bail is being forgotten nowadays. Right. But B.R. Gawai touched upon the principle that bail is a rule in the cases of Manish Sisodia versus Enforcement Directorate 2024. You may knowing this case. Manish Sisodia was the Deputy Chief Minister in the regime of Arvind Kejriwal's Aam Aadmi Party government. Liquor scam may be put for 100 crores. In that case, Manish Sisodia was first arrested, followed by Arvind Kejriwal, later Kavitha of Telangana. In the case of Manish Sisodia versus Enforcement Directorate 2024, as well as in the case of Kavitha versus Enforcement Directorate, you may be knowing, 2024. Kavitha, she is the daughter of erstwhile CM, ex-CM of Telangana, Kalvakuntla Kavitha. You can see the cases Kalvakuntla Kavitha versus Enforcement Directorate last year. Justice V.R.KRISHNA IYER, he was in favor of granting bail, of course, with the protective and curative conditions. He is always opposed to imposing onerous conditions of sureties which are not practicable. He believed that the under trials should not be jailed for longer period. Very innovative, very revolutionary thought. Of course, he is a CPI man, CPI communist man, not CPI, CPI. Right. So why Justice Gawai said they are forgotten? In cases of PMLA, that is Prevention of Money Laundering Act, and also UPA, Unlawful Activities Prevention Act. In a recent case, Justice M.M. Sundaresh and Arvind Kumar, two judges bench, they observed that under UPA or PMLA, jail is the rule and bail is an exception. Because we have seen the case of Vijay Mallya, Mohil Choksey, Nirav Modi. So if they are given bail, even not given bail, they have escaped. But what will happen? Definitely they will not follow the conditions. So in such cases, particularly the Money Laundering Act cases, jail should be the rule. They should be inside. Likewise, NDPS Act cases also. Justice V.R.KRISHNA IYER was one of the pioneers and he was one of the most transformative judicial-minded judges. His jurisprudence was not confined to courtrooms but reflected the struggles of common man. That is the greatness of V.R.KRISHNA. And our CJI referred to beautiful cases like State of Kerala versus N.M.Thomas, where he said that the V.R.Krishna said that the state must achieve actual equal partnership by making DPSP. The balance between DPSP and fundamental rights. I want to tell you, as students, you are under the impression that fundamental rights, yes, they are enforceable, therefore they are very powerful. But directive principles. What is our state? State means India. Ours is a welfare state. How the welfare measures are being carried on? Because of the directive principles which are mentioned right from 35 to 51 articles. So, in my view, DPSP are more powerful. But in your view, you say that they can't be enforceable. Therefore, honorable courts telling the government number of times, make a law. For example, welfare measure, Mahatma Gandhi National Rural Employment Generation Scheme. Yes, there is a law. Of course, the principle is welfare of the people, laborers who don't have work in certain seasons. So it is made into a law, yes, enforceable. Like that, the balance should be maintained. Definitely, DPSP should give way to the fundamental rights. Like Keshwanandavarthi case, DPSP and fundamental rights, they are two sides of the same coin. Constitutional coin. So they are symbiotic but not antagonistic. He also cited Idiga Annamma versus State of Uttar Pradesh 1974, where Honorable Justice V.R.KRISHNA commuted the death sentence to the life imprisonment. Rajendra Prasad versus State of Uttar Pradesh 1974. It is also a case against the so-called death penalty. So likewise, he was a revolutionist, I can say, a man who has turned from politician to so-called justice. Normalga jaragadi. So let us have a brief synopsis about Dr. Justice Vaijanathapuram Rama IYER Krishna IYER. Born on 15th November 1914, had a full term, 100 years. He died on 4th December 2014, 1 year, 1 month. He became a pioneer of judicial activism. He pioneered the legal aid movement in the country. He was a politician. He was a state minister in Kerala also. Born in Palghat, he was given Padma Bhushan also. He was conferred with Padma Vibhushan in the year 1999. His judgment continued to be cited in the Indian judiciary till now. He was looked as an ardent human rights activist. He served the jail terms. He was in jail for the cause of the poor and underprivileged clients. So, Justice V.R.KRISHNA here. He has jurisprudence, I will tell you. He made notable contributions in the field of constitutional law, focusing on social, political and civil rights. He was noted for the use of literary references in his judgments. Public interest litigation, just now I told you. Legal aid, right? So, very, very important person. And actually, Honorable Justice Gawai paid a tribute to him by delivering the lecture on his memorial. Okay. Read the experts, experts from his lecture and get enriched with the legal knowledge, and you'll be coming across so many cases. With this, I am concluding. Thank you very much.